Morning, Ashley. How are you doing today?
Good morning, Commissioner. I'm doing good. How about yourself?
Doing just fine, thank you. Everyone be ready to go at 9?
Yes, I'm ready.
Yeah, all set.
Thanks, everyone. All right, good morning, everyone. I'm Commissioner Easterday. This is my Thursday
This
morning.
message has been transcribed. One moment while I notify the caller.
Okay, I don't allow AI note takers in my virtual courtroom because it's my understanding that they record things. So I'm going to remove the item who I believe that came from, which is the phone number of 1-602-506-0000. So does anyone want to claim ownership of this AI note taker? I'll take that as a no. So phone number in the phone number, who is this? Do not, who am I speaking to?
This is Barbara Durbin.
All right, Miss Durbin, do you have an AI note taker? Are you recording this courtroom proceeding?
No.
Okay, who is? There's clearly someone who announced having an AI note taker. Who else? I'm talking to everyone else now.
I have no idea, sir. I got a notification in the mail, a default hearing.
Which is set for 9 o'clock, and I will get to it in due time. I have a lot of other matters set at 9 o'clock. But first,
Oh, yes.
Ms. Durbin, please, before I can proceed, I want to make sure that no one is recording this hearing. The only authorized individual that's allowed to record these proceedings, because this is court, is the official court recorder.
Yes, I know.
So who else?
No.
All right. Well, thank you, Ms. Durbin. Anyone else?
No, Your Honor.
Mr. Tucker?
No, sir, I'm on Teams.
All right. Ms. Dickman?
No, Your Honor.
Mr. Cups?
No, Your Honor.
Ms. Kazemi?
No, Your Honor, I'm on Teams.
Okay. Well, I'm going to take everyone on their word that no one is recording this. And if I find out that has occurred, well, I will be quite cross and will take appropriate matters. So everyone's on notice that no one is allowed to record these court proceedings because this is court. So sorry to come off a little hot this morning. Usually I like to think I'm not quite angry, but I do want to make sure that I do maintain proper decorum in my virtual court. So this is my 9 o'clock Thursday morning default calendar. I'm going to call up matters one at a time. I thank you in advance for your patience. So first matter I'd like to call is number 1 on my calendar, which is in the matter of Sanctuary at Avondale Homeowners versus Jose Ramirez et al. This case number is CB 2025-033655. Can I get appearances, please?
Good morning, Your Honor. Diane Dickman for the Sanctuary at Avondale Homeowners Association.
Good morning, Ms. Dickman. Do we have Jose Ramirez joining us or any of the other named defendants? Judging by the sounds, I'll take that as a no. It's 9:03. There's no one else waiting in my virtual lobby waiting to be admitted into the virtual court. So it does not appear that any defendant or defendant's attorney are timely appearing. So counsel, how to proceed with this matter?
Thank you, Your Honor. The association respectfully requests this court grant its proposed form of order and enter a default judgment in favor of the association. This is a breach of contract lien foreclosure case concerning the subject property. The property is governed by a declaration recorded against all properties in the association. The defendants were required to pay mandatory assessments as per the declaration, but failed to do so. Defendant Jose Ramirez waived service on February 3rd, 2026. Carlos Ora was served on October 14th, 2025. The defendant stipulated to judgment with Rio del Rey Homeowners Association, and the association filed a notice of dismissal of the defendant, the state of Arizona. The junior lien holder defendants, LVNV Funding LLC, was served on September 25th, 2025. The junior lien holder, Credit Acceptance Corp., was served on September 25th, 2025, and Kinno Financial Co. was served on September 26th, 2025. The association filed an amended application for default and affidavit on April 16th, 2026, and the defendants have all failed to answer this lawsuit in all time periods past. In conclusion, Your Honor, the plaintiffs respectfully request this court grant its proposed form of order and enter a default judgment in favor of the association.
All right. Well, this court has carefully considered counsel's statements. The court finds Ms. Dickman's recitation of the procedure history to be accurate. So I do find that defendants Jose Ramirez Carlos Ora, LV NV Funding, Credit Acceptance Corp., and Keno Financial to be in default. The other matters, defendants have either been dismissed or there's been a stipulation, as counsel has said. That's certainly reflected in my court file. So the aforementioned defendants are in default. Based upon the default, the complaint of the well-pled facts of the complaint are deemed judicially admitted. Based upon everything before me, I have reviewed the proposed form of judgment and decree of foreclosure and order of sale. Based upon the deemed judicially admitted facts, the court finds it is appropriate and will grant counsel's motion for a default judgment and enter the judgment and decree of foreclosure and order of sale here of record here today. So counsel, is there anything else we got to talk about in this matter?
No, Your Honor, thank you.
You're welcome. If there's nothing else, this matter is adjourned. I think you may be here on other matters, Ms. Dickman, but I'm not prepared for that, so I do apologize that I'm not going to be handling all of your matters in one fell swoop. Okay.
That's totally fine, Your Honor. Thank you.
Well, it's not totally fine, but thank you for your understanding. Next matter I'd like to call is in the matter of Mountain West Estates Homeowners Association versus Ruben Villalobos Castro et al. This case number is CB 2025-034850. Can I get appearances, please?
Good morning, Your Honor. Quentin Cups on behalf of the plaintiff.
Good morning, counsel. Do we have defendants Ruben Villalobos Castro or Maria A. Villalobos Castro joining us? Judging by that silence, I'll take that as a no. It is 9:07. This matter was set for 9 o'clock. Doesn't appear that any defendant or defendant's attorney are timely appearing. So, Mr. Cups, how are we looking to proceed with this matter this morning?
Thanks, Your Honor. Plaintiff has filed a complaint against the defendants for breach of contract and seeking to foreclose on its assessment lien secured against the property that the defendants own in the association. Defendants were served with the complaint back on September 30th, I believe, and an application for default was filed. I don't remember the date, but it was rejected because the switch in the form. So a new one was filed, I believe, in May. Since either one of those were filed, no responsive pleadings have been filed by the defendants. We have not had any communication with them regarding this lawsuit. So we are here seeking entry of default and a default judgment based on the form of order that was presented to the court.
Well, I do show that counsel is right. The complaint was filed back in September of last year. Both defendants, Ruben Castro and Maria Villalobos Castro, were served on September 30th of 2025, according to certificate of service filed on October 1st. I guess the operative or the amended application for entry default I show was filed on May 28th of this year. I do agree with counsel that neither defendant has filed an answer or other responsive or defensive filing that would apply under Rule 55. So I do find the defendants are in default. Based upon the default, the well-planned facts of the complaint are deemed judicially admitted. Based upon everything before me, I have reviewed the proposed form of default judgment. It is appropriate, and the court will grant counsel's motion seeking the default judgment and enter the default judgment of record here today. Mr. Cups, is there anything else we got to talk about on this matter?
I don't think so, Your Honor. I appreciate it.
You're welcome. Anything else? Do you have any other matters?
I think this is all I have today.
All right. Well, then have a great rest of your day. Then.
All right, you too. Thank you.
Bye-bye. All right. Next matter I'd like to call is number 3 on my calendar, which is in the matter of Viking Condo Corporation versus Barbara Jean Durbin et al. Case number CB 2025-039265. Can I get appearances, please?
Good morning, Your Honor. Diane Dickman for Viking Condo Corporation.
Good morning again, Ms. Dickman. Ms. Durbin, are you still with us?
Yes, I am.
All right, can you go ahead and introduce yourself by saying your name on the record, please?
I'm Barbara Jean Durbin.
All right, Ms. Durbin. I'm going to ask that you please raise your right hand. Let us know when it's raised because my clerk is going to swear you in, okay?
Okay, I'm ready.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you, Ms. Derby. You can go ahead and put your arm down now. While it's a little bit cooler outside, it's still hot and muggy. We don't want to be doing calisthenics this early morning. So, and just so you know, the reason why I had you sworn in is that Miss Dickman is an attorney. She's subject to all those rules and regulations that are enforceable by the state bar. I just wanted to put you and Miss Dickman on equal footing so I could carefully consider what everyone has to say. Okay.
No problem.
All right, so Miss Durbin, one more thing is I'm going to first ask Miss Dickman how she wants to proceed. She'll make any arguments in support of how she wants to proceed. Then I'm going to turn it over to you, and I'm going to allow you and I'll listen to what you have to tell me and make your argument, and then I'm going to make findings based upon the law. So I just want to give you a quick overview of what you can expect in your hearing. Okay, Ms. Durbin?
Yes, Your Honor.
All right, thank you. So, Ms. Dickman, this is the time set for a default hearing. How is your client looking to proceed this morning?
Thank you, Your Honor. The association respectfully requests this court grant the default judgment and enter the order. This case involves a breach of contract lien foreclosure concerning the subject property owned by Ms. Durbin. The property is governed by a declaration recorded against all properties in the association. The defendant was required to pay mandatory assessments. They failed to do so. Defendant was served pursuant to the order for allowing alternative service on March 31st, 2026. The association filed a application for default and affidavit. I believe it was amended, an amended one on May 4th, 2026. The defendant failed to answer this lawsuit. All time periods have passed. In conclusion, the plaintiffs respectfully request this court grant its proposed form of order and enter a default judgment in favor of the association.
Thank you, counsel. Ms. Durbin, what would you like to tell me? What would you like to tell the court?
I'm not sure what all that meant, but I have talked with CHDB Law, which is the people that I guess is handling this biking. And yes, I, have not paid it, but I'm back getting on my feet, and I had made arrangements with them, which they were going to present to Viking Condo of me paying $400 every 2 weeks toward my back pay, and then continue to pay my $253 HOA fees monthly.
Okay. Well, thank you, Ms. Durbin, for those statements. I'm not sure what agreement you have with, I guess, Viking, Ms. Dickman's client. I'm here to rule upon and make and hear about this lawsuit. Is there anything about the lawsuit you wish to tell me?
No, sir.
Okay. Okay. Ms. Dickman,
Yeah.
okay, that's perfectly fine. That's Ms. Dickman, anything you'd like to say in reply?
No, Your Honor, except the associations are often willing to enter into an agreement, and if it's not a settlement agreement, that is for, let me backtrack. If Ms. Durbin wants to reach out to our office after today's hearing to enter into a settlement agreement for this order, she's feel free to contact me directly, and I can give you my number, or you can call the person you were speaking with previously. But associations are often willing to enter into some type of a resolution after a default hearing and order is entered.
Thank you, Ms. Dickman. So, based upon everything before me, I find that the plaintiff's complaint was filed on October 27 of 2025. One of my colleagues here on the bench issued an order permitting alternate method of service, specifically mailing and posting at the subject address. I find that was accomplished on March 31st of 2026, according to the April 4th, 2026 certificate of service. There's no answer or other defensive filing filed within that time period. Plaintiffs then filed an application for entry default and affidavit on default separately, both on May 4th of 2026. And again, there was no answer or defensive filing within the allotted 10 business days. So I do find Ms. Durbin to be in default. Based upon the default, the well-pled facts of the complaint are deemed judicially admitted. This court has reviewed the matter. The court has specifically reviewed the proposed form of judgment and decree of foreclosure and order of sale. It is appropriate. The court will grant plaintiff's motion seeking a default judgment and enter the default judgment and decree of foreclosure and order of sale of record here today. So, Ms. Durbin, I'm going to sign the proposed judgment and enter it into record of this matter. You're certainly free to
Okay.
you're certainly free, if you so choose, to contact Ms. Dickman or her colleagues at her law firm and explore the possibility of a post-judgment settlement agreement. That's going to be between you and her law firm and her client. But for this court matter, I'm going to enter the judgment, okay?
Okay.
All right, so does anyone else have anything they wish to bring to my attention before we adjourn this matter?
No, Your Honor.
All right, well, hearing nothing.
How do I get a hold of this Miss Dickman?
Ms. Dickman's contact information is going to be on the legal papers that you should receive, but I do see that there's a telephone number of 480-427-2800. That should be the main line, I believe, for her law firm.
Okay.
That's the telephone number. I'm just reading straight off of all of the pleadings in the upper left-hand corner, okay?
Thank you, Your Honor.
And Ms. Dickman, did I misspeak? I should have
No,
let you
Your
say, I should have let you say your own law firm's phone number, but I just had it ready. So I was still staring at the judgment. It's on the upper left-hand corner, Ms. Durbin. So, okay,
Okay, thank you.
you're welcome. Well, if there's nothing else, then this matter is adjourned. Everyone have a good rest of your morning, okay?
Thank you, you too.
All right, next matter I'd like to call is in the matter of U.S. Bank National Association versus Edgar Chavez, case number CD 2025-039566. Can I get appearances, please, beginning with counsel for the plaintiff?
Good morning, Your Honor. Zara Kazemi on behalf of plaintiff.
Good morning, counsel. Do we have Edgar Chavez joining us?
Do we have what?
Do we have the defendant with us? I'm asking if the defendant is here. I hear nothing. I also see no one waiting in my virtual lobby, waiting to be admitted into the virtual courtroom. It's 9:17. This matter was set for 9 o'clock based upon my minute entry that I issued and filed on July 22nd of this year. So it doesn't appear that any defendant or defendant's attorney are finally appearing. Well, counsel, it looks like you saw my concerns, and I think you've subsequently filed a new application to entry default. Is that correct?
Correct.
And I showed that it's to both,
Addresses, yes.
yeah, the Gilbert and the Mesa addresses that I identified. So, okay, and that was done and mailed July 28th of 2026.
Correct.
Bad at math with that. Okay, so I show the 10th day would be yesterday. And I don't see an answer or any defensive filing filed as of yesterday. So counsel, how are you looking to proceed with this matter?
Would you please order the judgment on the default?
So you're now that you filed the amended application, you're still seeking to have the proposed form of default judgment entered?
Correct.
Okay. And just to be sure, I do show that the complaint in this breach of contract matter was filed on October 28th of last year. I showed the defendant, Edgar Chavez, was served at the Lindener Avenue Mesa address pursuant to a certificate of service filed December 26. What day was that? Looks like December 21 of 2025. There's no answer or other defensive filing filed. There was the application and affidavit for default filed on April 9, but that was sent to a Gilbert address,
Correct.
not the usual place of abode that was listed in the process server's certificate of service. I set today's hearing, and then you filed a new application on July 28th that has both addresses. Okay. And again, the 10th day was the 10 business days after July 28th is August 12th. And you have had have you had any contact with Mr. Chavez, counsel?
No, Your Honor.
Okay. All right. Well, I don't see any answer or defensive filing filed by Mr. Chavez at all. And it is after the 10 days. So I do find the defendant to be in default. Counsel, you're still seeking the capitalized principal of $15,202.55.
Yes, Your Honor.
Court cost in the amount of $553.30.
Correct.
Still waiving interest.
Yes, we
Okay.
don't seek attorney fees or interest on this matter.
Okay. Well, based upon everything before me, I'm going to grant counsel's motion for default judgment because I do find Mr. Edgar Chavez to be in default, and I will enter the default judgment here today based upon counsel's statements in her filings and also hearing, of course, since I had her live in person.
Thank you. Have a great day.
You're welcome. If there's nothing else, this matter is adjourned.
No problem. Have a good day.
You too. Bye-bye. All right, next matter I'd like to call is in the matter of L. Caro Vias Homeowners Association versus Linda Stodala et al. Case number CV 2026-000753. Can I get appearances, please?
Good morning, Your Honor. Diane Dickman for the association.
Good morning again, Ms. Dickman. Do we have anyone on behalf of Linda Stodala joining us? Judging by that silence, I'll take that as a no. It's 9:22. A matter is set for 9 o'clock. There's still no one waiting in my virtual lobby, so it doesn't appear that any defendant or defendant's attorney are talking about appearance. So, counsel, how does proceed in this matter?
Thank you, Your Honor. The association respectfully requests this court grant its proposed form of order and enter a default judgment in favor of the association. Again, this is a breach of contract lien foreclosure matter concerning the subject property. The property is governed by a declaration recorded against all properties in the association. The defendant was required to pay mandatory assessments as per the declaration, but failed to do so. The defendant was served on February 19th, 2026. The association filed a amended application for default and affidavit on April 27th, 2026. The defendant failed to answer this lawsuit and all time periods have passed. In conclusion, Your Honor, the plaintiffs respectfully request this court grant its proposed form of order and enter a default judgment in favor of the association.
I have carefully considered counsel's statements here. I've also reviewed the court file. I find counsel's recitation of procedure history to be accurate. So based upon that, I do find the defendant, Linda Stodala, is in default. Based upon the default, I've also reviewed, again, this matter and the proposed form of judgment decree of foreclosure and order of sale. It is appropriate. The court will enter the judgment and decree of foreclosure and order of sale here of record here today, granting counsel's motion seeking said default judgment. So, counsel, is there anything else we're going to talk about on this matter?
No, Your Honor.
All right, then this El Caro Vias Homeowners Association matter is adjourned. Next matter I'd like to call is in the matter of Garden Lakes Community Association versus Jose Cruz Beltran and specifically LVNV Funding LLC. This case number is CV 2026-009864. Can I get appearances, please?
Thank you, Your Honor. Diane Dickman for Garden Lakes Community Association.
Good morning again, Ms. Dickman. Do we have any defendants, in particular counsel for LVNV Funding? Judging by that silence, I'll take that as a no. It's now not 9:24. This matter was set for 9 o'clock. There's still no one waiting in my virtual lobby, so it does not appear that any defendant or defendant's attorney are timely appearing. So, Ms. Dickman, how would you like to proceed in this matter?
Thank you, Your Honor. The association respectfully requests this court grant its proposed form of order and enter a default judgment in favor of the association. The defendant, LVNV Funding LLC, is a junior lien holder inferior to the association's interest in an assessment lien. The defendant was served on March 17th, 2026. The association filed a application for a default affidavit on May 6, 2026, and the defendant failed to answer this lawsuit and all time periods have passed. Therefore, the association respectfully requests this court grant its proposed removal order, enter a default judgment in favor of the association.
And because it looks like there's still outstanding matter or parties, this is a Rule 54B as in boy.
Yes, that's correct, Your Honor.
Okay, just want to double check, make sure my T's are crossed and I's are dotted. So I do find counsel's recitation of the procedure history to be accurate. I do find LV funding to be in default based upon the default. In this court's review of this matter, the court will grant counsel's motion and order entering default judgment against LV Funding LLC only and record here today. And again, this is a Rule 54B because there's still other matters, and I think Mr. Beltran's still being that matter still being litigated with the other defendants. So there's that. Counsel, is that it? Is there anything else we got to talk about in this matter?
No, Your Honor, and that was my last one.
Well, then you have a great rest of your Thursday, okay, counsel?
Thank you, Your Honor.
Bye. All right, next matter I'd like to call is in the matter of well, let's go ahead and call in the matter of Convero AZ LLC versus Goodleap LLC. This case number is CV 2026-018466. Can I get appearances, please?
Good morning, Your Honor. Mark Tucker on behalf of the plaintiff, Convero AZ LLC.
Good morning, Mr. Tucker. Do we have any attorneys on behalf of Goodleap LLC? Judging by that overwhelming silence, I'll take that as a no. It is 9:26, matter set for 9 o'clock. There's still no one waiting in my virtual lobby, waiting admitted into this virtual courtroom. So it doesn't appear that any attorney is appearing on behalf of the defendant, Goodleap LLC. So counsel, as you know from I set today's hearing because it didn't look like this matter was set, well, it's not a some certain because you're looking to quiet title and a bunch of other matters.
Yes.
So how are you looking to proceed, counsel?
We'd like to proceed to get a default judgment quieting the title, Your Honor.
Well, why don't you go ahead and lay out the procedural history of this matter, why you believe Goodleap is in default, and why you and your client are entitled to relief you're seeking.
Sure. Thank you, Your Honor. Convero AZ LLC is the record owner of this property. They received a warranty deed recorded August 15th, 2023. In December of 2023, approximately 4 months later, the defendant Goodleap recorded a UCC financing statement identifying the prior owner as the debtor and encumbered the property. Goodleap has no agreement with Convero. They don't have any interest or relationship with Convero with regard to the property. And under ARS Section 33420D, that recording was unauthorized by law. So on November 12th, we sent a demand to Goodleap to remove their unauthorized encumbrance upon the property, and they haven't responded. This lawsuit was filed on May 5th, 2026. Goodleap was properly served with the summons and complaint. They failed to file an answer. We've applied for default. And so what we're asking for, Your Honor, is for the affirmative relief, quieting title to the property in favor of Convero and directing the release and discharge of the lien that's recorded against the property, declaring the UCC filing of the defendant groundless and awarding our statutory penalty of $5,000 plus court costs and attorney's fees. And a proposed form of judgment has been submitted to you, Your Honor.
Let's see here. Well, I do find that it looks like Goodleap was served on a stat agent back on May 13 of this year, 2026. I don't see an answer or any other defensive filing filed, so that led to the application for entry default on that was filed on June 3rd. Again, there's no answer or defensive filing within the allotted 10 business days. I do find Goodleap to be in default. So based upon my review of this matter and counsel's argument, I do find and I have also reviewed the proposed form of default judgments. I do find everything to be proper and reasonable. And I see the plaintiff's fees are awardable under ARS 33-420A and C. I had to look that statute up, counsel. That's not the typical statute that I see for awarding attorney's fees. So trust but verify, and I verified, and I do find your $2,587.50 attorney's fees to be reasonable, along with the $441.51 in costs also reasonable. So therefore, the court will grant your motion seeking the default judgment and enter the default judgment of record here today.
Thank you so much, Your Honor.
You're very welcome. Anything else we're going to talk about this morning,
Nope,
counsel?
that's my only thing today. Thank you, Your Honor.
You're very welcome. Well, go and enjoy the rest of your Thursday, sir.
I will. Thank you. You too. Bye.
All right. Last but certainly not least, I want to thank you for your patience. Let's go ahead and call Calvary SPV Roman numeral 1 LLC versus Sarah M. Dagoberg and Justin Sparf. This case number is CB 2026-013066. Can I get appearances, please?
Eric Wahlberg on behalf of Calvary.
Good morning, counsel. Do we have anyone on behalf of the defendants, Sarah Dagoberg, and or Justin Sparf? Well, judging by that silence, I'll take that as a no. This matter was set for 9 o'clock. It's 9:31, so it doesn't appear, and there's still no one waiting in my lobby waiting to be admitted, so it doesn't appear that any defendant or defendant's attorney untimely appearing. So, counsel, as you know from setting this hearing, you're seeking a default judgment against Justin Sparf only, and I had questions about whether the application of default was sent to the right property. So I'm happy to hear argument about this.
Well, I, as a former process server, I can tell you that I see that the couple in question, which is these two folks, okay, they have since split. They sent the process server thinking that they were sending it to Miss Dogberg's. Well, they thought they were sending it to Mr. Sparf's address, and actually it was sending it to her address. Okay, so when he served Miss Dogberg, he thought he was serving the address of Mr. Sparf, and we did send the address, the application for default to the correct address that we have for Mr. Sparf, but unfortunately, the affidavit of service was on an address that he no longer resides. And since both those addresses were in the system as proper addresses, there was some confusion as to who they actually served. So bottom line, we're going to drop the default for now because we have to serve everybody properly. We're in negotiations and contact with both defendants. So, but I thought I would get online and explain that to you, as opposed to just asking it to be vacated.
All right. Well, thank you. So so you said you're going to drop the default. So what exactly does that mean? What do you asking me to do, if anything?
Nothing really, because we basically we haven't filed an affidavit of service for either defendant properly. Okay, so we tried the one and we actually got the other, but we didn't file that affidavit of service correctly. So there's nothing for the court to do other than vacate these proceedings, and we'll go forward with trying to get service if we can't resolve the matter.
Okay, so I guess what I'm hearing is that you agree that Justin Sparf was not properly served.
Correct.
Okay. Well, based upon that, I want to thank you for your patience, your candor, and letting me know. Basically, I do appreciate it. I do set these hearings for a reason. There's a method behind the madness.
Right. Right.
So I'm going to not proceed with any further with today's default judgment hearing. So I'm going to set aside any default that may have been entered against Justin Sparf because he was not properly served based upon counsel's arguments. That is under Rule 55C and incorporating specifically Rule 60B6. I'm going to strike the June 11, 2026 application for entry default just to make a clean record for any judicial officer moving forward, because again, based upon counsel's motion or statements, Justin Sparf was not properly served, for therefore he cannot be properly in default. I'm going to deny the June 30th, 2026 motion for default judgment because again, he's not in default, so you can't enter default judgment. So based upon that, I'm going to refer this matter back to Judge Mata and Judge Mata's division because default proceedings are no longer appropriate because again, no default defendants in default. Everything's kind of circular right back to there. And the reason I know you know this, counsel, but I'm babbling and trying to make a clean record for anyone who wants to review my work can do so. Trying to be nice to my colleagues on the Court of Appeals.
Understood.
And also, and let's see here. Well, you say that you are in consultation with the defendants or speaking to them. I'm going to put this matter on the default calendar for October 13 of 2026. So so the default calendar deadline is October 13 of 2026. Specifically, this matter will be dismissed without further notice unless prior to October 13, 2026, a proper judgment is entered or filed, a stipulation for dismissal is presented, or a proper joint report and proposed scheduling order is filed. Okay, counsel? Just want to make sure that this doesn't get lost and forgotten about, okay?
I understand. I appreciate that.
All right. Well, again, thank you for being here. Thank you for your patience. It's not fun being last, but someone had to draw the short straw, and that just happened to be you this morning, counsel. But is there anything else we got to talk about?
Nothing else, Your Honor.
All right. Well, thank you again, and this matter is adjourned. Have a good rest of your day, okay?
You too.
Hello, Marcher Pan. What matter are you appearing for?
Hi, I'm appearing for the amendment of my birth certificate. Hello,
What's your case number?
my case number is 2026-024030.
Okay, that is before Commissioner Seltzer. I'm gonna go ahead and put the teams in the chat for you. And if you click that link, it will take you to their teams.
Okay, so where's the I see the chair. So you said it was going to be in the chat?
Yes, it should be. It's the tiny URL link, PCC05.
And once I click it, it should take me to the right
It should
courtroom?
take you, yes, correct.
Okay, because I this is the link that I was given, so I hope I'm not late for the other one.
That is interesting. Okay, yes, I would go there now,
Okay, thank you.
of course.
Ya, mandaron el link equivocado. Déjenme ver si puedo entrar al otro. Think sending me to the same one.
I have also emailed it over to you if that will work better.
Yeah, I think it's sending me to this. It keeps sending me to this one.
Okay, give me 1 second.
Yeah.
Okay, maybe try leaving this Teams and then
Okay.
clicking on the link.
Okay.
Hey, Commissioner, this is Ashley. I'm going to be getting up from my desk to go pick up some of those default packets.
All right, thanks for the heads up.
Hey, Commissioner, I'm back. Security closed off access to East Court building for now, so I'll head up there a little later.
Okay, thanks for the heads up. I'm curious as to why security is blocking access to East Court building. That's a little disconcerting, but thank you.
Yeah, of course. It was that whole hallway, like connected to Central building that they closed off, and they said all the entrances are going to be closed off for now. So
Interesting. Well, thanks for the gossip or heads up.
Yeah, of course.
everyone be ready to go with the 11:15?
Ready?
Yep.
Yes.
All right, good morning, everyone. I'm Commissioner Easterday. I'm going to go ahead and call number 9 on my calendar, which is in the matter of Calvary Chapel Desert Hills versus Michelle Rails. Case number is CB 2026-027372. Can I get appearances, please, beginning with counsel for the plaintiff?
Good morning, Your Honor. Christopher Charles with Provident Law, appearing on behalf of the plaintiff, Calvary Chapel Desert Hills.
Good morning, counsel. And I believe we have attorney for the defendant, Michelle Rails, now, too. Is that correct?
Yes, Your Honor. Good morning. John Lohr on behalf of Michelle Rails.
Okay. So good morning to both of you. I see we have some other people appearing. Do we want to get their appearances as well? Jerry Knorr, can you, I don't know, tell me, announce your presence? Or is someone from the Calvary Chapel Desert Hills? Your microphone's on. Am I speaking to?
Hi, this is Kristen David from Calvary Chapel Desert Hills. Jerry Knorr is also a member of the church.
Okay, well, good morning to both of you as well. So this is the time set for, I guess it's an order to show cause hearing, but I'm a little confused about what we're doing here today. I'm Commissioner Easterday, and commissioners on the civil department handle eviction matters. And I see the cover sheet marked eviction action. I do see that the complaint for special action filed on July 2nd, 2026 lists the forcible detainer statutes. In addition, a bunch of other claims like quiet title, constructive trust, resulting trust, and then ARS 33-420 subsection C. Yeah, go ahead, Mr. Charles.
Thank you, Judge. Yes, this is a special action complaint under 33-420, where this church seeks to quiet title, clear title, secure title to the church property against Ms. Rails, who is the current spouse of the former pastor of the church, Pastor Rich. So we filed this special action complaint. Simultaneously, we filed a application for special action and application for order to show cause. And I did receive notice that this matter was appointed to you, which surprised me because I did not understand that you handle special action hearings. So I exchanged emails with the staff on July 28th and expressed my surprise that it was appointed to you, and clarified that this was a petition for a special action. And I received a message back that is what it was set for with you. So I said, okay, that's news to me, but we'll proceed. But it is an urgent matter. We have the pastor has moved out, was terminated by the church in January has moved out of the property, but his wife, his current wife, Ms. Rails, they are separated, but she is still basically squatting in the property as far as the church is concerned. And so it is very, very urgent to the church that the church secures possession of this property back so they continue with their ministry. And so that's why we brought this expedited matter.
Well, counsel, you're using some terminology that's very different, and I would like to point out that the civil cover sheet that was filed contemporaneously with your complaint, July 2nd, 2026, the only thing was marked was eviction action, forcible and special detainer, which is how it got forwarded to me. And under the eviction actions, the forcible entry and detainer, which is what you saw in count 5, that is a speedy resolution matter where the only thing the judicial office, whether it's a justice of the court, JP, a civil commissioner, or superior court judge, handles is only who has the superior right of possession, not title. You can't litigate title. It can be introduced as ancillary to prove who has the superior right of possession, but that's the only thing I'm supposed to handle in an eviction action.
So, Judge, we are not seeking the eviction. We are reserving the right to pursue the eviction once we correct title.
It's in count 5, counsel. So you're not reserving anything. You alleged it. And again, your cover sheet said this is an eviction action.
Judge, we did file an amended cover sheet and an amended summons, focusing exclusively on the special action, and we are not seeking an eviction hearing at this time.
Well, what do you suggest? Because this is right now coded and as a, I don't see your amended cover sheet. What's your suggestion, counsel? Because I can't, I mean, if this were to be an eviction action, there's a whole slew of things wrong under Rule 5 of the eviction action procedure. So I'm not sure what I'm being requested to do right now.
This is not an eviction action, as I clarified in the emails with the staff. We are not seeking an eviction. We're seeking a hearing on the special action. So if to the extent that we need to vacate the hearing today, if that's all that you're able to hear is eviction, we're not proceeding on an eviction at this time. We need to get this set for a special action hearing.
Okay, so
might I make a suggestion?
Yes, counsel, go ahead.
I think that what probably needs to happen is that just the order needs to be issued referring this to the judge on the case to actually hear this emergency motion for special action to determine whether or not it proceeds on that. So I think the right concept was, having a return hearing, but I think the wrong concept was having it go to you, the commissioner, instead of the actual judge on the case.
Well, there's no other assigned judge because the cover sheet, the only cover sheet that's filed is me. So, I mean, it is an interesting concept, but again, as far as I'm concerned, I'm the only assigned judicial officer in what is the only, and again, I see the amended complaint filed July 30th that still has forcible entry and detainer as count 5. So again, as I'm going to refer to some case law under United Effort Plan Trust versus Home, specific, which is 209 Arizona 347, pinpoint site 350 to 351. Paragraph 21 which is a great primer on Arizona eviction law. Although the fact of title may be admitted if incidental to proving a right of possession, the merits of title cannot be litigated in an eviction action, specifically citing the forcible entry and detainer. The only issue to be cited in the action is the right of actual possession. Thus, the only appropriate judgment is the dismissal of the complaint or the grant of possession to the plaintiff. Again, this has been coded as an eviction action based upon plaintiff's own cover sheet. There's no, and counsel, I heard you where you said that there's an amended cover sheet. I don't see it filed. I see an amended complaint for special action, which again lists count 5, forcible entry and detainer, along with quiet title, constructive trust, and all the other matters that I cited earlier. Or not matters, but claims. So since plaintiff, you have sought this as a eviction action, this does not appear to be a proper eviction action, nor is it appropriate under Rule 5 of the Arizona Rules of Procedure for Eviction Action, because it doesn't list some of the mandatory language under Rule 5B6. There are other ancillary matters that are just not appropriate for an eviction action. What I'm fixing to do, to use a great Southern phrase, is to dismiss this matter without prejudice, seal the matter under Rule 20, and allow plaintiff to go and file a new action if they so choose, just to make a clean record, because as far as the court and I'm concerned, and even the plaintiff's own cover sheet, this is an eviction action. Thoughts?
Yes, I'm thinking, Your Honor.
And again, if I sound frustrated or angry, I'm not frustrated or angry. This is just a unique situation, and I'm thinking on my feet as I scramble to prepare for like what is before me. So
yeah,
don't think I'm angry at anyone.
It is strategically pled exactly the way it is, and I have handled matters with evictions in other claims where I have, staged the proceeding that way. But I understand that you're not having that. And it's gotten in those cases, it was assigned to a judge, not to you as the eviction commissioner. What if I voluntarily dismiss everything but the special action? Could you then refer it to like the presiding judge? If I just voluntarily dismiss without prejudice the eviction, that's all that it would be. I'm just voluntarily dismissing the eviction, because the other claims all relate to the special action, and then have it reassigned to the presiding judge.
So dismiss count 5.
Yes.
Okay, and then refer this to Judge Blanchard, the department presiding for assignment. Mr. Lord, that's almost kind of like what you were suggesting earlier. What are your thoughts on that plan?
Yeah, I agree. I think that's the appropriate course of action. I mean, I would love a dismissal, but yeah, I think that that's probably not appropriate.
Okay. All right. Well, I know you'd love a dismissal, but it would be, I mean, no matter if I were to dismiss it, it would be without prejudice to allow it to refile. So this might save some, if things work out the way I think we're all contemplating, this would save some judicial economy and some resources down the road. So I like that plan. So what I'm prepared to do is find that this is not a proper eviction action. So based upon plaintiff's counsel's oral motion to dismiss count 5, the forcible entry and detainer count, granting said motion, count 5 is dismissed. Further, this matter is being referred to Judge Blanchard as the department presiding for the Civil Department of the Superior Court for assignment, as this is not an eviction action. This is not a proper use of commissioner resources.
Yes, Judge, and just to clarify, without prejudice, the dismissal.
Without prejudice, yes, without prejudice, count 5 is dismissed. Thank you for that. Thinking and speaking at the same time is often dangerous. Well, thank you for being here. Is there anything else we got to talk about that I can handle as a commissioner on this matter?
No, Your Honor.
Mr. Nora?
So.
All right.
No, Your Honor. Thank you.
Well, thank you, everyone, and best of luck, and have a great rest of your Thursday, okay?
You too. Right, thanks, you too.
Yeah. Bye.
Morning. Hello?
Hi, my name is Miguel. I am Commissioner Easterday's judicial assistant. There are currently no more hearings scheduled for this morning. Do you have a case number for a hearing you're looking to attend, sir?
I do.
Can I please have it?
I think this is at 674-991-104. It
That's,
was, I'm sorry. I apologize, sir. It was a case for Scott Amrine.
all right, sir. Normally the case number start with either CV or another letter. Do you have a case number of that nature? Because the
I
one
do
you
not.
provided.
I'm sorry, sir. I do not have that.
Okay. Are you a party in this case, sir?
I'm party. I'm something about a garnishment to my from Pirelli and law offices. It said on the thing it would be held at 11:30 today. That's why I was calling him with this ID number.
Yeah, give me 1 second.
I'm sorry, sir.
All right, sir. So it looks like that hearing was vacated and reset to September 23rd at 10 a.m.
September 23rd at 8 a.m.
10 a.m.
Oh, 10 a.m. I'm sorry, sir. 10
Oh, no worries.
Okay. And that was September the 23rd, correct, sir?
Yes.
Okay. I appreciate it so much.
No problem. Have a great day.
All righty, sir. Bye-bye.
Hi, my name is Miguel. I'm Commissioner Easterday's Judicial Assistant. I just submitted a Sheila Kimbrell. Ms. Kimbrell, we do not have any hearings going on until 1:30. So were you looking to observe or did you have a hearing for Commissioner Easterday? Hello, Ms. Kimbrell?
Yes, can you hear me?
I can hear you now. Do
Okay,
you have a
yes,
case number?
Oh, yeah, hold on just a second. I might, they just gave me the link to click on there. Hang on a second.
Okay.
Bears me with a second. The case number is CV 2026027372.
All right. Thank you so much. Okay. Alrighty, so are you a party in this case?
yes, well, yes.
Okay, this case actually has already been called and already concluded, so if you're
Okay,
looking
that's
to
fine.
obtain a,
Okay, it's
Alright.
okay. I didn't have to be there, so it's okay.
sounds good.
Thank you so much.
Thank you.
Bye-bye.